interactive session. Ladies and gentlemen, we will now move on to the regional update segment of the conference. The regional updates has become a fixture in all RAIF conferences now, and it is where each member institute is accorded the opportunity of sharing with the audience the recent developments and trends in arbitration in their respective jurisdiction. The session will be sponsored by, has been sponsored by the Charlton Martin Group, and it will be moderated by the Chief Executive Officer of the Charlton Martin Group, Mr. Rodney Martin. Mr. Martin is no stranger to the arbitration scene in Malaysia, having lived and worked in KL for close to 22 decades. Yes. He has extensive experience as a quantitative surveyor in the construction industry and is an accredited mediator. He is listed as a panel arbitrator and adjudicator with the KLRCA and holds the unique distinction of being a fellow of both the Chartered Institute of Arbitrators as well as the Malaysian Institute of Arbitrators. Without further ado, could I invite Mr. Rodney Martin up onto the stage to begin the next session.
Thank you very much. Distinguished guests, ladies and gentlemen. Excuse me. It's a great pleasure for me to moderate this session. I realize that I've actually worked in all of the countries that we'll cover today in the RAIF organization, and it's always interesting to experience the different cultures in all of those countries. Slight change to the plan. We're going to have 3 of the regional updates before lunch instead of 4, and we'll be dealing with Hong Kong, the Philippines, and Australia first. Now, I'll introduce the speakers in turn in a little bit of detail as they come up, but I'll just let you know, to begin with, we're going to have Samuel Wong from Hong Kong, Teddy Kalau from Philippines, Agus Kartasamacha from Indonesia, Rowena McNally from Australia, Chan Leng Sun from Singapore, Daud Ismail from Brunei, and Lam Ko Loon from Malaysia. So if I could just please invite the first 3 regional update speakers, Samuel Wong, Teddy Kalau, and Rowena McNally, to join me on the stage, please. Thank you. We're going to start with, as I said, Samuel. If I could just ask Samuel to take the lectern, and I'll just go through the highlights of his details. You've got all of his profile details in your packs, but I'll just say Samuel is the president of the Hong Kong Institute of Arbitrators. He's a practicing barrister, chartered arbitrator, and accredited mediator. He's a member of the International Chamber of Commerce Hong Kong and its arbitration committee, as well as various mainland China economic and trade commissions. His involvement in various task forces include the Hong Kong Department of Justice Working Group on Arbitration Law Reform and the ICC Arbitration Rules Review in 2009. Please again welcome Samuel Wong. Thank you.
Thank you. Speakers and guests, Salamat Datang. I'm asked to give a short country report on Hong Kong, limited to about 8 minutes, so I will quickly get on with it. One of the recent developments in Hong Kong is the government's initiative to enhance Hong Kong's position as a regional arbitration center for Asia and Pacific. With that, the government is putting more resources into promoting Hong Kong arbitration. This includes setting up of a committee with stakeholders to advise and coordinate development and promotion of Hong Kong as Asia Pacific Arbitration Center, and also to facilitate provision of dispute resolution services in mainland China by Hong Kong professionals. Now, in tandem is the setting up of government of task force, one by the Secretary for Commerce and economic development on IP trading, including IP arbitration and mediation. The second is the Department of Justice effort to promote maritime arbitrations in Hong Kong. Now, the government has also taken a step forward. We are not getting anything like the Bangunan Sulaiman here for KRCA, but the government is now considering providing space for legal and arbitration organizations in the former wing of the government central offices. Now, in tandem with that, recently, the Hong Kong government has also provided space for the Permanent Court of Arbitration to be located in Hong Kong. This is pursuant to an agreement entered into by the Permanent Court of Arbitration with the host country, PRC. Now, in addition to government efforts to promote Hong Kong arbitration, the Hong Kong Institute of Arbitrators has also spearheaded, together with the Guangzhou Arbitration Commission, to start the Nansha Arbitration Center in China. Now, under the rules of the NAC, for arbitration to be conducted under the NAC, rules other than the PRC arbitration rules can be used. So, such as the Hong Kong HKIAC arbitration rules can be used for arbitration under the NAC. Now, HKIAC has also been doing work in revising our domestic arbitration rules into a new set of rules for 2014 and the issuance of the HKIAC 2015 procedures for administered arbitration under UNCITRAL arbitration law in Hong Kong. Under this new procedures, parties may designate HKIAC, that is the Hong Kong International Arbitration Center, to be the appointing authority, but without subjecting the arbitration to full administration under HKIAC's administered arbitration rules. So this provides for a light touch administered arbitration in Hong Kong. Now, I've been asked to address a number of issues in this country report. One is to talk about UNCITRAL model law. Now, Hong Kong has always been a model law jurisdiction, whether under the Repeal Ordinance Cap 341, the former ordinance applying to Hong Kong, or under the new Hong Kong Arbitration Ordinance, the current ordinance, Chapter 609. Under the current ordinance, provision of the UNCITRAL model law are adopted into the ordinance as sections of the ordinance with supplements. So it is apt to say that Hong Kong is a model law jurisdiction. Now, another issue I'm asked to address is the additional educational and promotion initiatives taken in Hong Kong. The HK Hong Kong Institute of Arbitrators has continued to offer courses, entry courses as well as fellowship courses. And then we are conducting a lot of special topic talks, such as a series of talks on international sales of goods, CISG, and maritime issues in Hong Kong. We are offering continually monthly talks such as on arbitrability and on maritime fraud. We have invited noted speakers from overseas. Recently, Sir Bernard Eder and Professor Neil Andrews from Cambridge University. Hong Kong International Arbitration Center, Hong Kong Institute of Arbitrators also regularly paid networking visits to PRC arbitration commissions and to promote connection between Hong Kong arbitration and PRC institutions. The most recent one is the Greater China Arbitration Forum, which we held on the 6th of May this year. Now, other institutions present in Hong Kong also organize numerous events. This includes talks organized by the Charter Institute East Asia Branch, ICC Hong Kong, and the CTEC Hong Kong Center. Notable upcoming events in Hong Kong include ICMA, ICMA, the International Congress of Maritime Arbitrators Conference this month, as well as the Hong Kong Summit, organized in conjunction with ICA. Now, as far as investment treaty arbitration is concerned, as I mentioned, the Permanent Court of Arbitration has set up office in Hong Kong. The PCA was set up in 1899 to administer state-to-state dispute arbitration. Now, the current situation is that HCA arbitrations modeled under the UNCITRAL arbitration rules 2010 version are regularly being used. And there's an increased role for PCA in investor-state disputes. Now, insofar as Hong Kong is concerned, Hong Kong has concluded over 20 BITs, while China is a signatory to over 120 BITs. So there is the possibility of disputes being resolved in Hong Kong by PCA. Now, as to interim measures, Hong Kong has always been in the forefront to enforce